This is Gregory Wright, who is accused of committing an armed robbery in Detroit, Michigan. On June 28, 1995, the 22-year-old Wright allegedly held Gregory Greiton at gunpoint and stole his car. During his escape, Wright crashed into a police vehicle and shot at the officers, injuring one in the arm. He was captured by the police the following day on June 29th.
All I got to say is I have no remorse for police officer. He got what he deserved if I had opportunity.
Now facing trial, Gregory Wright is charged with armed robbery, carrying a concealed weapon, and using a firearm during a felony. He appeared in court for a pre-trial bond hearing. Judge Azetta Bright set his bond at $50,000. Upon hearing the judge's decision, Wright attempted to flee the courtroom. It took 7 officers to subdue Wright after he attempted to flee. Following the altercation, Judge Bright revoked the bond and ordered that Wright be held in custody. The case later went to trial, where Wright was convicted and sentenced to life in prison. The case of Mitchell Blair is both heartbreaking and shocking, echoing deeply with both the community and the legal system. Mitchell Blair, a mother to 4, horrified everyone when she tragically ended the lives of 2 of her children.
We could see where Nikki's bare feet exited and re-entered through that door.
That definitely did happen to me. That's why I know exactly how would have grew up.
I don't believe anything they say. Everything they said, whether it had some truth or fiction in it.
You get what I'm saying? So all I could do is go back and sit in my room and just sit there and look stupid. I'm a kid.
I think I picked up a knife and I stabbed her.
Where did you stab her?
I think I stabbed her in the stomach.
So do you believe that the violent person you went on to become you were a product of your own childhood?
Kind of like a joint effort.
I try hard to get over that, but anybody who knows me, that touching the kids, the molesting, that no.
The discovery of her 1-year-old son, Steven, and her 13-year-old son, Stoney's bodies in a freezer brought immense sorrow and disbelief. Throughout the court proceedings, Mitchell Blair's behavior was erratic and disturbing. She frequently became agitated, screaming and explaining her reasons for the horrific acts she committed.
At one time, you did realize that morning your mom.
Yeah.
She had so many strokes, and I'm telling you what my problem was, always with you.
When they were awakened to go to school for by their mother, and I think that's what sparked the attack.
She want to walk around like she big and bad all day. My mama, you big and bad, everybody's scared of you.
And cleaning it up, and then they went to school so that they would have an alibi.
And this is why I say my kids knew better, because I've always told them everything that happened to me.
And even to the point that they said in their writings, that if they didn't get rid of her soon.
You never talked to me about like this, but when I did come to you, you didn't do.
He interviewed that resident. He recalled someone yelling.
Blair asserted that her actions were justified because she believed her daughter had mistreated her siblings. However, no evidence emerged to support these claims. Her erratic and disruptive behavior throughout the proceedings made the trial particularly challenging. Blair's frequent outbursts and assertions led to her being repeatedly removed from the courtroom, which complicated the progression of the trial. It's crucial to remember that the judicial system strives to conduct fair and just trials, weighing all the evidence and testimonies presented. In this instance, the absence of evidence backing Blair's claims significantly influenced the court's decision, leading to her conviction for the appalling crime she committed.
Can you talk me through the type of abuse that you had to suffer as a kid?
You mean sexual abuse?
So we would surmise that she was pulled back into the house where the attack resumed.
I told my mother what happened to me, and the only thing she said was, "It's over with, so what the you want me to do about it?"
He heard someone ring his doorbell. He was in bed at the time, and he didn't get up to go investigate.
Telling you what happened to me, you didn't do about it. And plus, I still had to see the person coming in and out my house. You still friends with that person.
I think I had her hands, I guess her feet.
I mean, everybody have choices, so I can't just blame all that on my mom because I was still an adult.
She was heavy. We just put it in. The water was turned on.
Mitchell Blair was sentenced to life in prison without the possibility of parole. This means she will spend the remainder of her life behind bars, with no chance to seek release or be considered for parole.
I even tried to talk to my mom when I got in my mid-20s. She had strokes and things like that, and I'm like, Mom,
They didn't want to get up.
asked you to do something. The person lives around the corner on this particular time, it was just a woman named but when I come to you with some real and I tell you what happened to me, you didn't walk your around that corner and do to that woman.
And they would write back and forth to each other how much they disliked their mother.
I told them why, because I don't understand why it took me so long to tell my mom when I was a kid.
This was an act of rage. It was, the two girls had planned for this.
This is Aubrey Trail, a murder suspect from Lincoln, Nebraska. At the age of 52, Trail, with the assistance of an accomplice, murdered Sydney Loof. Reports indicate that Bailey Boswell, Trail's partner, met 24-year-old Loof on Tinder and lured her to their apartment. There, Trail and Boswell committed a violent act against Loof, involving an extension cord, and then gruesomely handled her remains with tools purchased from a home improvement store. They wrapped her remains in trash bags and abandoned them along a rural road. Loof was reported missing by her family the following day when she didn't show up for work. Following the crime, Trail and Boswell fled the state and posted videos on social media denying their involvement in Loof's disappearance.
Just curious, are we not allowed to tell our side of this? Again, I'm just a criminal, so you're going to believe none of this, and I guess it's really irrelevant. We have apparently this lady. I'm a thief, but I mean, goddamn, I've never seen one in my life. I've never heard a female in my life, so take that for whatever the hell it's worth.
Trail and Boswell were arrested in Missouri on November 30th, 2017, and faced charges of first-degree murder and improper disposal of human remains. During his interrogation, Trail claimed that Loof's death was accidental.
There was lots of there was strangulation involved. It was not supposed to go as far as it did, but it did. Well, you don't remember why you bought things. You don't remember why you're going places. She was laid as she was because we believe in that position, and because of what's missing from her, that she will come back.
Trail pleaded not guilty to the murder charges, but admitted guilt for the improper disposal of human remains. In a shocking turn of events during his trial, Trail attempted suicide in the courtroom by slashing his throat with a razor blade he had managed to smuggle in, all in front of the judge and jury.
Stop recording.
After making a full recovery from his self-inflicted injuries, Aubrey Trail was found guilty on all charges. On June 9th, 2021, he was sentenced to death. This is the case of Andrew Worth, who is suspected of a double murder in Jefferson, Wisconsin. On December 6, 2009, Worth fatally shot off-duty police officer Jennifer Lewick and her boyfriend Greg Peters outside a bar. The incident reportedly began when Lewick bumped into Worth on the dance floor. After an exchange of words, Peters came to Lewick's defense and confronted Worth outside the bar. Worth claimed he acted in self-defense, alleging he saw Peters reaching for a gun. According to witness Scott Trader, Lewick initially survived the shooting and managed to stumble back into the bar seeking help. Trader reported that when he went outside, he saw Worth pointing a gun at Peters' head and shouting at him. Worth then walked away as Peters lay struggling.
Yelled, call 911, he's got a gun. And then she was standing there for a few minutes and then collapsed. And nobody had even known that she was at that point.
Andrew Worth was quickly arrested and charged with 2 counts of first-degree intentional homicide. His bail was set at $1 million in cash. During his court appearance, Worth's emotions erupted, and he made a sudden leap towards the families of the victims. He had to be restrained by several court officers to prevent any further escalation. Police Chief Jim Wallace was standing close to Lewick's family when Worth lunged forward. After the trial, Worth was acquitted of the 2 counts of first-degree intentional homicide, but was found guilty of 2 counts of homicide by negligent handling of a dangerous weapon. He received a sentence of 10 years in prison. During her sentencing, Regina Johnson, who who was convicted of the murders of her husband and daughter, displayed extreme anger.
Prosecutors argue Johnson struggled with severe paranoia and depression.
When he put that down and I picked it up, I panicked and I was afraid, and I thought that was his daughter too, but
San Marcos woman accused of executing her family.
Regina Johnson fell apart talking about her 14-year-old daughter, Aaliyah.
Despite her defense that she acted in self-defense against an abusive boyfriend, Regina Johnson was found guilty of both murders. During her trial, she had an outburst where she wrote accusatory messages on a mirror using red lipstick, blaming her husband for her actions. Ultimately, she was sentenced to 80 years in prison, effectively ensuring she would spend the rest of her life behind bars.
Only 3 people know for sure what happened in the house that day, and 2 of them are
that Aaliyah, she was the love of my life.
Johnson says she endured years of and in self-defense.
If I don't pick this gun up right now, he might try to kill me.
And Johnson stayed in the house with the 2 bodies for 3 days.
Kenneth Freeman is a murder suspect from Milwaukee, Wisconsin. In 2019, he was accused of the brutal murder of nurse practitioner Carly Bowden in a parking garage. Reports suggest that Freeman allegedly assaulted her, dragged her to her car, and then repeatedly ran over her with the vehicle. He was then arrested and charged with homicide. During his court hearing, Freeman's behavior was disruptive. He began using profanity and hurling insults at the judge, the prosecutors, and the families of the victims.
I do have reason to believe that competency is an issue in this case.
Freeman ignored the judge's orders and continued his disruptive rant in the courtroom. The judge then instructed the deputies to use a stun gun on him to halt his disruptive behavior. After a doctor's report deemed Freeman competent for trial, he was ordered to remain in a state mental institution. Later, in 2020, Freeman received a lifelong commitment to the Wisconsin Department of Health Services. He was deemed not guilty due to a mental disease or defect. This case centered on a 29-year-old man named Travis Jeffrey Ranking. On April 22, 2018, on Murfreesboro Pike in Antioch, Nashville, Tennessee, Travis fatally shot 4 people and injured 2 others. His shooting spree was halted by an unarmed man who wrestled the rifle away. Ranking was captured the following day, ending a 34-day manhunt. Then, he was charged for his crime. The proceedings against Ranking began due to the severity of his offense. Both prosecutors and defendants delivered their initial speeches.
The punishment phase of this trial, and except for jury selection, obviously, it pretty much procedurally will be the same as the regular trial was. So there will be opening statements, some evidentiary testimony presented to you, this type of thing, and some closing arguments, and I'll charge you on the law as it relates to the punishment phase. All right? So, may proceed.
Trying to say without having any opening statement as such, because of the nature of this part of the hearing, but we would, to put on the record, I think procedurally, is that at this point in the trial, the state is relying upon 2 aggravating circumstances. Number 1, the defendant knowingly created a great risk of death to 2 or more persons other than the victim during the act of, and 2, the defendant committed massacre, which is defined as of 3 or more persons, whether committed during a single criminal episode or at different times within a 48-month period, and would ask the jury to consider as part of the proof in this case the evidence that was presented during the guilt-innocence phase of the trial, And with the court's approval, we would now ask to be allowed to call victim impact witnesses.
Good morning. I want to start by saying that although we disagree with your verdict, we fully respect your decision and appreciate the work y'all put into this case to this point. We just see things a little differently, but we nevertheless respect what you've done and appreciate the work that you put in on this. Now we're going to a different phase in this case, and you're going to have a choice. You're going to have a choice between two options, and those options deal with what's going to happen with Travis Reinking from this point forward. One of the choices that you're going to have is to sentence him to life imprisonment with the possibility of release at some point. You may or may not have been aware of this at this point, and the jury instruction will say this, but that decision means life imprisonment with the possibility of release after serving 51 calendar years in prison. So what you've done by your verdict is, at a minimum, you've already sentenced him to a minimum of 51 calendar years in prison. At his age, you can ask yourself, do you think he'll ever make it out, even if he had that opportunity for parole? So one decision you have is, do we sentence him to life in prison with the possibility of release after 51 calendar years, or do we just say life in prison without the possibility of parole? That's the two decisions, the two choices. In factoring in what your decision should be, as the state said, 1/2 of the scale is the aggravating circumstances that they believe they have proven in this case. On the other hand, we have what are called mitigating circumstances. Now, the proof that you can consider in the aggravating circumstances and the mitigating circumstances can come from whatever you see today.
The defendant delivered a detailed speech outlining some of Travis's justifying factors.
That we're going to be relying on all the mental health proof that we put on in the trial. You would consider that just as if we spent 2 days doing the same thing again. So anything that you have heard, seen, observed, that from the beginning of this trial up and through today, you can consider in determining whether or not an aggravating circumstance or a mitigating circumstance applies in this case. We believe that when you weigh that evidence, you're going to find 5 mitigating factors. They mentioned the 2 that they believe they have proven. We're going to mention the 5 that we believe we have proven. Those 5 that we believe we have proven are: the defendant has no significant history of criminal activity. You've heard about an arrest, and that would be prior to this incident, but you've heard about the arrest in D.C. for what he did there. But we think that applies in this case. The next mitigating factor was committed while the defendant was under the influence of extreme mental or emotional disturbance. I think that's as clear and absolute as it could possibly be. The murder was committed under circumstances what the defendant reasonably believed to provide a moral justification for the defendant's conduct. He believed that moral justification. The capacity of the defendant to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of the law was substantially impaired as a result of mental disease or defect or intoxication, which was insufficient to establish a defense to the crime, but what substantially affected his judgment. These 4 that I've read so far, there's a 5th one, but these 4 come from our statutes that said the legislature believes that these are statutory mitigating factors that you can consider. We no longer have a burden of proof to prove these by clear and convincing evidence. In fact, you can find this on your own. We don't have the burden of proof on that. You can find this on your own. And so those things basically in a nutshell means that although you apparently didn't believe that our mental health proof was enough to rise to a defense, it certainly can be enough to sentence him to life with the possibility of parole after serving 51 years, as opposed to life without the possibility of parole. The fifth mitigating factor is any other mitigating factor which is raised by the evidence produced by either the prosecution or the defense at either the guilt or sentencing hearing. That is, you shall consider any aspect of the defendant's character or record or any aspect or circumstance of the offense favorable to the defendant which is supported by the evidence. That means anything else that you individually find to be mitigating in this case. Some of you may find some of the mitigating factors exist. Some of you may disagree. When it comes time to weigh these, some of you may give great weight to some of these. You may give great weight to his mental health situation in determining what the punishment would be. Some of you may not be as moved by a particular mitigating evidence. But what's happening here is the 12 of you are basically making your own individual decision as to weighing out the statutory aggravators and mitigators and deciding for yourself, should Travis be punished by being sentenced to life imprisonment after serving 51 calendar years in the Tennessee Department of Corrections, or do we need to up that to just say life without parole? And each of you make your own individual decision with that. So after you hear the proof today, and at the end of this sentencing hearing, you can consider everything you've heard from last Monday morning all the way through today. You can look at the statutory aggravating circumstances, look at the mitigating circumstances that will be in here, and each of you individually get to weigh your decision as to what is his punishment from this day forward. And obviously, we are asking you to sentence him to life imprisonment with the possibility of parole after serving 51 calendar years in prison.
The prosecution emphasized the severity of the criminal's actions, highlighting Ranking's involvement in a felony crime. Unsurprisingly, the prosecutor stressed the severity of his offenses, ending in his misdeeds.
Sent to her some years ago, and again, we agreed that that was fine, just between the parties, that she could go ahead and review the ones that she omitted or did not consider prior to giving her report, doing her written report.
None of which are on this list?
Correct. They're referred to as intended to be provided to Dr. Wood. I believe that's referenced the journal. That's what we call it, the journal, but there are quite a few entries there. General Norman and I met with Dr. Kovach January the 12th at his office for a couple of hours. So apparently they do not intend to ask Dr. Kovach to review anything else, and certainly understand why. But that creates a significant problem. And as you can see from General Norman's email, once she and I discussed this last night, it's like, Bruno, please hold off until we can present this matter to the court. We want this trial to go forward more than anyone can imagine. And I'm sure the court does as well.
Absolutely.
Absolutely. And we want it to go forward, but it being a fair trial for the state of Tennessee and a fair trial for Mr. Reinke. We feel like we have done everything in our power as required by law to give Mr. Reinke a fair trial. But here at the last minute, bringing this up, and this was something that could have been discussed, I submit, last Monday when we filed the motion in limine, which was directed essentially to this area, or a couple of motions in limine to get anything out of the way that could be a problem. You know, the Wise case, which says, it'd be a good idea to meet with the judge and go over everything. Well, we were here. And counsel stood up and says, we have no problem, we have no objections, we intend to follow the law and don't have a problem with it. So we forge on ahead, pick the jury, and there's no mention until last night. The defense saying following videos may be played. That I submit is perhaps another issue which goes into Rule 703. If the experts have viewed them, then we get into all of the whether it's admissible. The court would have to do a screening process about that. If they intend to just play these, I guess we'll have to see how that works out. But there would have to be relevant statements by a party opponent if that's what we get into. There's all sorts of evidentiary issues before we get to that of them just saying, well, Judge, we're popping in another video. And it has to be relevant to a contested issue. And we're talking about, I think I don't know if you can correct me, but my impression is that all of these videos were created prior to the commission of the offense and not on the date of the commission of the offense. So they have been in existence for years. They have been known to counsel, I would submit, for years. This is, as far as being a non-contested issue, to the extent that would go towards whether he was suffering from a severe mental illness, it may require a jury out here when we get to that point. But the more concerning is that when he says Dr. Wood and Dr. Eisen will be providing copies in the morning. Would ask that if the defense feels that this is something that is so important to their case, to have the doctors review these when they've had years.
The defendant presented various pieces of evidence supporting his client's protection. However, he encountered numerous obstacles along the way.
Just like we could provide anything else over the past 4 years to them for them to consider. Alternatively, and I think it's much more inefficient, they can both sit here in this front row during this entire trial and watch evidence come in, and we can, assuming it's admissible, play videos and stuff along those lines, and they can factor that in. So there's nothing that's inappropriate about us continuing to provide something. Quite frankly, I could, if something happened today in this trial that would affect their opinions potentially, I can provide it to them tonight. So I don't, the law is on our side with the disclosure. Now, when it comes to this agreement, the agreement was not, I will ask the state for permission about what I can give to the experts. The agreement, both sides wanted to know everything that the experts had. Okay, we wanted to know everything that they reviewed. The agreement was if one side sent something to an expert, we would let the state have the copy, or if they sent something to an expert, they would let us have it, so that everybody knows what the experts have. There wouldn't be any backdoor giving the experts information that the other side's not aware the expert has in the case. So
but at this stage of the game, and I understand your 703 argument, but at this stage of the game, isn't it sort of backdooring?
It's not backdooring, because as we're prepping this case, and we continue to go through stuff and what might be coming in evidence, what we might want to be putting in evidence, is we click something that we think might be appropriate for them to consider in their testimony, then we can give it to them. Just like if we sit here in trial, let's say Wednesday, something happens in this trial that is relevant, we're going to send it to them.
Why wasn't the material provided earlier, since it was available earlier to the experts?
We hadn't, quite frankly, we hadn't gone, there are so many videos in this case, we hadn't gone through all of the videos and then narrowed it down to what we thought might be most relevant until last week and this weekend. That's why yesterday we finished our discussions over what we thought might be most relevant to their information, might be most relevant to their opinions in the case. The state has had, almost all of them the state has had, so that it's not like they're not aware that they exist or the substance of them. But
what is your position on the state's argument that if this material, and I have no idea what's in it, I mean, you gave me a summation, has to deal with possible delusional behaviors, the thought processes before this event that brings us here today. That's what I know about him. What about the state's position that we prepared for trial based on this is what the experts are likely to testify to, And with the addition of this, it may change their arguments, and we may want to get our own rebuttal expert.
I don't know how, the substance of it is, so we'll start with this. All those materials, okay, what Mr. Moore was referring to, I think he made a statement somewhat to the effect, they go to a non-contested issue, in his opinion, which is schizophrenia, okay? If it's a non-contested issue on their end, I don't know why they would need to run out and get another expert.
Well, because I don't think the issue in this case is that he had a severe mental disease or defect. It's the concept. It's what, if any, effect that had on his behaviors on this occasion.
Yeah. Right. So that's why I don't think there's a need to go out to get a rebuttal expert, because those issues would go towards the schizophrenia issues.
That's contained.
There's a couple that are in close in time, a couple of weeks before or so the incident. It gets closer in, and so, but a majority of them are things that happen over a period of time. But again, it goes to it's an issue dealing with more towards the schizophrenia, that part of it. So if it's generally a non-contested issue, why would they have a need to go get another expert? There's no need to get a rebuttal expert if they're not in effect contesting that part of the issue.
Then what's the need to even bring them up at this stage of the proceeding?
Because we have a burden of proof.
The judge started speaking and requested additional information.
Influence an expert opinion, why it wasn't provided much earlier under rules of discovery. What they hear during the course of the trial and things that may come up during the course of the trial or immediately leading up to it, I'm not disputing they might be able to, that they could possibly rely on under 703, but when you have all of this massive amount of materials that has been in existence forever and wasn't provided to them, I don't think that is the same as what you're arguing here. I agree that things come up during the course of a trial that may influence how an expert looks at things and are not required to go back and type a report. But when they have ample opportunity to review and consider thoroughly, fully, and as a part of their reports that are required under Rule 16, why it wasn't done. Why is it just now coming up? This isn't something that they're sitting in trial and they might hear and they go, oh my gosh, I didn't know about that. I need to change my thought process.
So I don't know if it's a Rule 16 issue, because that's our obligation to give things to the state, discovery things to the state. I don't think that's the obligation that goes towards what we have to provide an expert in advance. So let's say the court's going down this road. Then in the middle of the trial, if we get these videos into evidence at that point, then I don't know of any reason why an expert can't look at it at that particular time. Now, what that's going to do potentially is they have time to look at it. So what that might do is, as they come in, and then we tell the court we want to give that to the expert, they have to have time to review it. And what I'm trying to do is cut that off, give it to them today, so that when it comes time for them to testify, they've reviewed it. So I don't think 703 prevents us from giving them additional information of whatever we find. If we continue to go through discovery or files or whatever else, and we find something else that we think is relevant to our issue, we can give it to them, because they haven't testified yet. And that's all we're trying to do with it. And it also makes things more efficient. So I think Rule 7.
Well, it'd been more efficient if they had it 3 years ago, rather than the morning of trial.
I agree with that, but they didn't. And so, but nevertheless, Rule 703 allows us to provide the information.
It was a choice the defense made, whether that's by strategy, that this was a plan 3 years ago to do this or not. I have no way of knowing, obviously, other than they said they can make everything he said in his word that they're going through this. But that begs the question of why so late.
Well, that's what I was trying to get to.
Absolutely, absolutely. And why now? Why the morning of trial? As opposed to, yes, we'll have Dr. Eisen come sit through all of the testimony and see what is introduced. Now, they want to send her things that may well not be introduced for all the other reasons that I've said. That's where the problem lies. And if she has days, weeks to go over that, and we're certainly going to be rather busy to be able to speak with her. And yes, I agree. If something that comes out in court, that's not what they're wanting to do. They're wanting to send her a ton of materials literally after the jury's been sworn and jeopardy is attached. And that's not fair.
No. Anything else?
It's not about fair. It's about the rules. It's about the rules. And so the other way this stuff could happen, and fine, we have all the time in the world, but the other way this stuff could happen is they could cross-examine an expert, and then we could start pulling these out. And there's a roughly 250-page journal that's typewritten that might be handed to an expert at that point, and she can take whatever time she needs to read it on a redirect after a cross-examination. So, all of this stuff is relevant to the issue, to our burden of proof. We have it under the rule. We're allowed to do it, and if that's the way we prefer to do it, because that is the way that's going to make this thing most efficient. But we have all the time in the world, and if we have to do it another way, so be it. But I don't think that we've done anything but follow what the rule provides.
The prosecutor provided copies of evidence detailing Reinking's wrongdoing.
As issues come up, Your Honor would have to rule on those as they come and discuss with counsel that perhaps, if Your Honor would like, to have the reports in hand to review. I know we won't get there probably for a couple of weeks, maybe.
It'd still be nice to have them. I haven't, there's been no discovery openly filed in this case. I don't have a clue what's in the file.
Yes, Your Honor. Yeah.
I can't even get my clerk to let me take a peek.
So in any event, yes, just so the court, as we go through, there may be objections, and if so, we would ask to approach the bench and or get into any of that. But no, I think we're in agreement as to what the law is, and we'll endeavor to follow it. Did have a couple of housekeeping matters.
Sure.
With Your Honor, and counsel is aware of this as well. Count 2 of the original indictment had a misspelling, a typo in the spelling of one of the deceased names. And so by agreement, we would like to substitute. I have several copies. In other words, unstaple, take out the count 2 and put that in.
All right.
And that's all it was. It was one letter left out. And just to put on the record, the state is going to take a nollie as to count 17.
The just unlawful weapon possession?
Yes, Your Honor. Given the recent legislation that there's probably no crime under current law, and so it only being a misdemeanor. I think that for clarity's sake, and I believe the clerk has already adjusted the indictment accordingly.
We will enter a nollie on count 17. Anything else?
As far as the jury questionnaire, I think parties are in agreement about that. And a question, at least that I had, was given the coverage of whether Your Honor intended to use the jurors' names or to have them referred to by their jury number.
I prefer, and I'm even in a case that doesn't carry much publicity. I've had jurors complain for years that their identity gets known and things of this nature. Unless there's an objection, I would prefer that we go by their jury number.
That's what the state would prefer.
Now, I have issued an order, and you should have gotten it last week, that prohibits the news media from publishing or otherwise broadcasting the names of any jurors. Did y'all not get that?
I don't recall. No, Your Honor.
Okay, well, I'll find out what happened. Oh, wait a minute, I think I may have just put it in, I think I sent it to the news media. If you didn't get it, I apologize.
Well, that's fine. That may appear odd than why I was talking about it.
if you're already
Yeah, I
issued an order.
apologize. I could have sworn that went to all the proper parties, but yes. So, numbers work for me. I guess we'll have to educate them on their little number, which is, I assume, the one that's on the master list.
Yes, Your Honor. That's what I would think.
Yeah.
And then, of course, that could be redone when they become jurors number 1, 2, 3, 4, 5.
And if you haven't tried a case, number 1 seat is top left, going left to right, and then 8 through 14 be bottom left to right. Okay?
The defendant also attempted to demonstrate Reinking's mental state during the commission of the crime.
Portable podium just for a second.
Yes, sir.
As to where we normally put it.
Yes, sir.
During,
We still have a problem with our playback system, so when they come to the bench, if they can be sure to talk into this.
I was just advised by the court reporter, and it'll go over behind the court reporter. It's got a small tape recorder up here, or if that's what they're still called. I don't even know what they're called anymore since they don't use tapes. But be that as it may, we're still having some difficulties when we put on the white noise. It's still interfering with the discussions that go on at the bench on a bench hearing. So he'll have the microphone, his recorder there. Just make sure you are standing close to the recorder when you talk so that he can pick it up. He or she, whoever may be here that day.
Judge, would perhaps now, could we, one of us approach, one from each side approach?
Sure. Tom, where are you going to normally put that? Over here?
Yes, Your Honor.
I mean, all of you can kind of come up and look at. And I'm, just normally kind of lean forward like this.
That's the problem.
Yeah, kind of, and therefore it interferes with the sound, but recorder will be right there. Y'all can move closer.
That's what I didn't.
Yeah, no, you can come up to the bench.
Okay.
Come on up. That's why I want you to wear a mask up here.
Yeah.
Okay, but that way you can, and if he punches you in the back, then get closer and speak directly into it. But it's pretty sensitive, isn't it?
Let me put you over on this end.
Yeah.
Actually, Judge, there is something that we could approach the bench about.
Did you get any of that? With the mask, you gotta speak a little bit louder. All right, is there anything else that we need to address this morning?
No.
Okay. I'll get these emails to you just to review it and see if there's anything that needs to be added, subtracted, modified, clarified, whatever the case may be for tomorrow. And hopefully we won't have, we had 190 who were supposed to show up. Hopefully we won't have 190 hardships, but we'll see how it unfolds.
Well, at least there won't be any conflict with a Sunday afternoon football game.
No, we don't have to worry about that. In fact, yesterday morning I called a couple of friends of mine and I said, what time is it that the Titans are supposed to play? Because they didn't play on Saturday. And I got a guy coming up here at 10 o'clock to get sworn in as an attorney, and he's really glad that we had difficulty getting together, and he's really glad that we're doing it today because his parents are from Ohio and they came down for the game. So I sent him the order about no paraphernalia with any insignias, wording, or anything else on it. Anything else? Thank you all very much, and we'll see you here. It'll probably be 9:15, 9:30 before we go down, because it takes a while to get them all in the building, get them situated in there and stuff like that. So if you want one day, just one day, Miss Norman, you can be here at 9 o'clock.
Thank you, Judge.
All right, you get 30 minutes of extra sleep time, prep time, whatever you want to do.
The jury read the severity of Reinking's crimes, which was significant and deeply shameful. However, this verdict undoubtedly does not alleviate the pain experienced by the families of the victims.
Madam Foreperson, if you would please stand. Mr. Reinking, if you would please stand. And he will just read the verdict of the jury.
In the Criminal Court of Davidson County, Tennessee, Division 6, State of Tennessee versus Travis J. Rankin, case number 2019-A-55. Jury verdict form. Count 1. We, the jury, unanimously find Travis J. Rankin for the offense of premeditated first degree guilty. Count 2, we the jury unanimously find Travis J. Rankin for the offense of premeditated first degree guilty. Count 3, we the jury unanimously find Travis J. Rankin for the offense of premeditated first degree guilty. Count 4, we the jury unanimously find Travis J. Rankin for the offense of premeditated first degree guilty. We the jury, count 5, we the jury unanimously find Travis J. Rankin for the offense of attempt to commit premeditated first degree with serious bodily injury guilty. Count 6, we the jury unanimously find Travis J. Rankin for the offense of unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony guilty. Count 7, we the jury unanimously find Travis J. Rankin for the offense of attempt to commit premeditated first degree with serious bodily injury guilty. Count 8, we the jury unanimously find Travis J. Rankin for the offense of unlawful employment of a during the commission of or attempt to commit a dangerous felony guilty. Count 9, we the jury unanimously find Travis J. Rankin for the offense of attempt to commit premeditated first degree guilty. Count 10, we the jury unanimously find Travis J. Rankin for the offense of unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony guilty. Count 11, we the jury unanimously find Travis J. Rankin for the offense of attempt to commit premeditated first degree guilty. Count 12, we the jury unanimously find Travis J. Rankin for the offense of unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony guilty. Count 13, we the jury unanimously find Travis J. Rankin for the offense of first degree felony guilty. Count 14, we the jury unanimously find Travis J. Rankin for the offense of first degree guilty. Count 15, we the jury unanimously find Travis J. Rankin for the offense of first degree felony guilty. Count 16, we the jury unanimously find Travis J. Rankin for the offense of first degree felony guilty.
You may be seated. You may be seated. Is there anything else from the state?
Not at this point.
No, I understand that. Anything from the defense at this point?
No, Your Honor.
All right. All right, members of the jury.
The judge issued the sentence based on the jury's statements, following the usual course of proceedings.
Try and put it out of your head and get refreshed and come back here tomorrow open-minded and ready to listen to the next phase of the trial as it relates to whether or not Mr. Ryan King should be sentenced to life with or without parole. And there'll be different, it's the same type of procedure, but the evidence and what both sides will be presenting will be somewhat different than what's been going on so far. So just go back and enjoy your evening, relax, and we'll start back up at 9 o'clock in the morning.
All right, ladies and gentlemen, this way, please.
All right. Anything else for tonight? Well, we got some things we need to talk about, but anything else up to this point in time as to what the jury has done? All right, have a seat, and we'll kind of plan out how we're going to proceed tomorrow. I guess one of the issues is, do we charge the law as it existed in 2018, or do we charge the law as it now exists for sentencing purposes?
Judge, Mr. Bruno and I saw that, looked at it a little bit. The state's position that the 2018 law would, in essence, be more favorable, and it's required to be whichever law is most favorable.
That's the way I read it, because under the 18 law, it's parole after 25 years.
Oh, I'm not talking about that. No, we're talking about the...
Well, you don't want to weigh the factors.
Correct. Actually, under the law now, the jury could impose a sentence of life without parole without finding an aggravating circumstance, and I don't think they would want that.
Right. The old law, you had to find one an aggravating factor.
But Your Honor, the requirement about how much time, that has been 51 years for many, many years, even though the pattern jury instruction and the statute.
The statute says 25. That's what I was going to ask y'all about.
But
it's always been 51.
It's always been 51, and that's been charged, and in the pattern instruction, there's a notation or a footnote that says statute hasn't been amended, however, a court should charge 51, and so I believe that's the appropriate.
Yeah, I agree, but I was going to ask if there was an issue about the statute. I think the law has been clear since the 89 Act was put into effect, but for some reason they put 25 in there. I don't know why. So we're going to go with the 18?
Yes, sir.
I will, I've kind of redid it thinking the 18 would be the applicable one. I'll send that back out to you. I've got a few things to add to the basic required instructions by statute. Some of the general instructions and some of the concluding instructions and things like that, and the prefatory instructions, and credibility of witnesses I put back in there. So just a few things like that. Anything else?
I can say for whatever planning purposes, based on the aggravating circumstances the state has alleged, we will be relying upon the facts previously introduced and no new factual evidence, and assuming the court finds, as it's required to, that the state has proven an aggravating circumstance, then we would proceed with victim impact testimony. And those two aggravating
I think those are kind of
have been, by the jury's verdict, resolved.
Absolutely. I mean, those findings have been made.
Yes, sir. Thank you.
How long do you think your presentation will be?
So we have 4 families. And
at least.
Well, no.
Well, that's right, because you're
we're
dealing with just the homicides.
Yes, Your Honor, to the homicide victims' families. In this hearing, we've explained that in
There's
the
another
other sentencing hearing, all the others, and actually the victim's family could come back and testify to that as well. But I would think 2 hours, two and a half at most.
Okay. No, I'm just trying to plan their day
No,
tomorrow.
that's what I said before.
Deborah Milka's story is one of profound tragedy and injustice. Born in West Berlin, Germany in 1964, she relocated to the United States with her family at the age of 11. In 1984, she married Mark Milka, and they welcomed their son, Christopher, in 1985. However, the couple's marriage ended in divorce just 3 years later, in 1988. On December 2nd, 1989, Christopher was taken to the mall to meet Santa Claus, but tragically never returned home. His lifeless body was discovered in the desert, having been shot 3 times in the back of the head. Deborah Milka was arrested and charged with his murder, leading to her conviction and sentencing to death. At the time, she became the youngest woman on death row in the United States. Throughout her trial and subsequent appeals, Milka steadfastly maintained her innocence, asserting that she had been framed by her roommate, James Lynn Steers, and his friend Roger Mark Scott. Both Steers and Scott were convicted of the crime and also sentenced to death. In a significant turn of events in 2013, the 9th U.S. Circuit Court of Appeals overturned Milka's conviction. The court cited the history of misconduct by Detective Armando Saldat, who had conducted the coercive interrogation of Milka. This decision led to Milka's release from prison that same year. Since regaining her freedom, Deborah Milka has been an outspoken supporter of criminal justice reform and highlighted the system's flaws and injustices. Her case serves as a reminder of the unreliability of the death penalty and the biases present within the criminal justice system, particularly concerning women and minorities. Lisa Montgomery was born on February 27, 1968, in Malvern, Kansas, the second of 4 children to Judy Shaughnessy and her first husband. Montgomery's upbringing was troubled. Her mother struggled with alcoholism, and her father was abusive. From the age of 11, Montgomery was physically assaulted by her stepfather and his friends. She also battled mental health issues, including depression and post-traumatic stress disorder. In 1986, Montgomery married her first husband, Carl Bowman, and they had 2 children together. The marriage was marked by abuse, leading Montgomery to file for divorce in 1996. The following year, she married her second husband, Kevin Montgomery, with whom she had another 2 children. On a tragic day in December 2004, Montgomery visited the home of Bobby Jo Stinnett, who was 8 months pregnant. There, Montgomery strangled Stinnett and horrifically removed the unborn baby from her womb.
The family said that they will hope that their privacy will be respected.
We will never forget the members of the law enforcement who found Bobby Jo in less than 24 hours.
Lisa Montgomery becomes just the 3rd woman scheduled for execution in the federal system.
The baby, a girl named Victoria Jo, survived and was returned to her father. Montgomery was arrested the following day and charged with kidnapping, resulting in death. She was convicted in 2007 and sentenced to death. Montgomery's death sentence was initially scheduled for January 13, 2021. However, it was delayed several times due to legal challenges. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.